Welcome to Zoom In, Zoom Out, your global look at news from Taiwan and around the world. I'm Herel Hughes. Within the past year, we've seen both leaders and countries sued in international courts under the pretext of violating international law. But what are these courts made of? And what are the consequences of violating international law? To learn more, we are joined today by Professor Kevin Chang. Kevin teaches international law at National Zhengji University in Taipei and has more than 20 years professional experience serving the United Nations, the International Committee of the Red Cross, and the Australian government. Kevin, welcome to the show.
Thank you. My pleasure to be here.
Just to begin, we want to zoom out and establish some context on this topic. There are several ongoing wars, and what people may not know is that there are very specific laws around the governance conducting warfare. Can you tell us a bit more about what these laws are?
So there's sort of two main elements. One element relates to the legitimacy of a state to wage war. It is prohibited to invade another country, to breach the territorial integrity of another country, for example, the case of Russia and Ukraine. The use of force is limited to only self-defense or when it's authorized by the UN Security Council. But then the much bigger sort of complex field is what happens once a war is underway. And generally they're governed by the field, what we know as international humanitarian law. So they relate to really principles to protect civilians from harm and very sort of strict rules around how hostility should be conducted to maximize protection to civilians and those not involved in warfare.
Why were these laws invented in the first place?
The father of the Geneva International Humanitarian Law is a Swiss businessman called Henri Dunant, and basically he was on a business trip to Italy and he saw the carnage of the war. He came back with the help of the Swiss government, set up the beginning of the International Committee of the Red Cross.
Can you specify some of the rules in international law?
There must be distinction between civilians and combatants, and that attacks against civilians or civilian objects, which include, of course, schools, hospitals, places of worship, power supply, they are prohibited, and that any indiscriminate attack which cannot find distinction between civilian or military object, that's also prohibited under international humanitarian law. If the harm to civilians is disproportional to the military advantage, then even if it's a legitimate military target, those attacks cannot happen. The third element is the principle of precaution, which says that all parties to conflict must take maximum care in sparing civilian harm.
Who is required to follow these laws?
International humanitarian law applies equally to all parties, to whether it's state armies or non-state armed groups. In relation to sort of international crimes, so the international humanitarian law are captured mainly by the 4 Geneva Conventions and the 2 additional protocols. In addition to that, we have a series of international crimes, and of course, a serious breach or a grave breach of the Geneva Convention, they can constitute so-called war crimes. Now, war crimes, crimes against humanity, and genocide.
So we've just talked about the Geneva Convention, which seems geared towards humanitarian response around warfare. What about the Genocide Convention?
Both the genocide and the Geneva Convention were response to the atrocities of the Second World War. A main part of that was the Holocaust of the Jewish people. It was international community's commitment to never again relating to those atrocities. Now, the Genocide Convention specifically is an international treaty that binds states. So the prohibited acts include intention to destroy, in whole or in part, so it doesn't have to be the entire group, of a national, ethnic, racial, or religious group. Now, this includes the following: killing members of that group, causing seriously or mental harm of that group, deliberately inflicting conditions of life calculated to bring about its destruction, imposing measures intended to prevent birth within the group, and also forcibly transferring children from that group to another. So there's a very high threshold to cross when it comes to genocide. It's not only you have to prove the act, you have to prove the intention to do so.
Who decides whether international criminal laws have been broken?
So it's important to have a distinction between the International Criminal Court, which is a criminal tribunal for individuals, and the International Court of Justice, which is a general court for states on all matters of international law. So often those matters are not so much about seeking compensation from the state, but rather to bring accountability and also relief for the victims. In terms of who decides, there's also another important source of authority of international law, which is the United Nations Security Council, made up of 15 states. Now, of course, there are all sorts of problems with the makeup of the UN Security Council and the effect of the veto vote, but nevertheless, States, the UN Security Council has the primary responsibility to seize itself of matters of international peace and security. And all states have agreed under the UN Charter to comply with decisions of the UN Security Council. So when the UN Security Council makes a decision, that's an authoritative decision under international law, and all states must comply with that.
So you mentioned the International Criminal Court, and that is geared towards specific people who are committing these acts. What about the International Court of Justice?
Yeah, the International Court of Justice is a principal judicial organ of the United Nations. So the International Court of Justice deals with any matters under international law. It delivers two kinds of judgment. So firstly, dispute between states, but important to note that it's a dispute between states, and it's a court of the United Nations. The second thing that the ICJ does is to provide advisory opinion when it's requested by UN organs. And one of the very important proceedings underway is actually right now relating to the legality of Israel's ongoing occupation of the Palestinian territories. But these advisory opinions generally do have an effect, of course, clarifying international law, but also deterring unlawful activities.
So what exactly happens after the court gives an advisory opinion? What comes after then?
So the advisory opinion, strictly speaking, is not legally binding because it doesn't have parties, it doesn't have states involved. Advisory opinions of the ICJ are taken to be very authoritative in stating a particular international law issue. They are extremely influential, but there's nothing specific to be complied.
Now that we have a good basis for international law and the different ways it's enforced, I want to zoom in on two specific examples, and I want to start with South Africa versus Israel. Can you tell us more about the background of this case?
So these are the sort of 5 main points of South Africa presented to the court. Firstly, South Africa claims that there's been mass killing of Palestinians. More than 30,000 people have been killed in Gaza since October 7. South Africa presented evidence of mass graves and that Israel has deployed highly destructive 2,000-pound bombs in parts of Gaza that Israel itself declared were safe zones. The second part relates to bodily and mental harm. It's alleged on the people of Gaza that more than 70,000 people have been wounded and maimed. South Africa also talked about the arrest of large numbers of Palestinians, including children who were undressed and loaded onto trucks to unknown locations. The third element relates to forced displacement and food blockade. The fourth element relates to the destruction of the healthcare system. This healthcare system was already crippled by years of conflict and now is simply unable to cope with the sheer number of injured people needing life-saving treatment. And finally, South Africa alleges that Israel is preventing Palestinian births, that Israel is blocking critical life-saving treatment required to deliver babies.
So now we want to go into the specific legalities around South Africa versus Israel. What is being alleged and why?
So South Africa and Israel are both parties to the 1948 Genocide Convention. And this case of the ICJ is brought under that. South Africa is alleging that Israel is responsible for violations of the Genocide Convention with respect of its actions in Gaza. South Africa said that Israel has deliberately imposed conditions that life cannot be sustained. As we recall, that's one of the prohibitions of the Genocide Convention. South Africa claims that Israel has also imposed conditions denying Palestinians adequate shelter, clothes, bedding, and other critical non-food items, and that there's no safe water to drink. One evidence including how Israel gave entire hospital an order to evacuate within 24 hours. It did the same for large parts of northern Gaza, where more than 1 million people were asked to move at very short notice. And South Africa claims that such a notice itself, such an intention itself, is genocidal. South Africa has used many statements released by Israel officials as part of its evidence. For example, Prime Minister Netanyahu's citing of the Amalek being persecutors of biblical Israelites and therefore that they must be destroyed. Defense Minister Yoav Gallant said that Israel was fighting human animals. Another example was that the Deputy Knesset Speaker wrote on Twitter that Israel had one common goal, which is to erase Gaza Strip from the face of the earth. So these are evidence that South Africa provides as genocidal intent, not merely the very disturbing videos that we see posted by Israeli soldiers, but also it's claimed by South Africa that this genocidal intent is actually systematic, coming from the very top.
You've mentioned that they have mounting evidence, they're collecting from social media, from officials, and this case is currently ongoing. How effective would the ICJ be within this case?
Often the hardest thing to prove in a genocide case is not merely these actions, but that it did so with genocidal intent. and this has to be proven beyond reasonable doubt. So it's important to note that the arguments presented by South Africa and also Israel are both framed in the context of genocidal acts and genocidal intention. So therefore, elements of war crimes, so indiscriminate killing of civilians and so on, and crimes against humanity, they're not directly applicable to this case in the International Court of Justice. So that's a matter for investigation by the International Criminal Court.
So the International Court of Justice, have they given any recent orders? Has there been any updates on this case?
So on the 26th of January 2024, the court ordered provisional measures. Now, provisional measures are urgent measures that must be implemented with urgency. So the ICJ has not decided whether Israel has committed genocide or not, but in the meantime, Israel must, according to the ICJ, take all measures within its power to prevent the commission of acts prohibited under the Genocide Convention. And also, Israel must allow immediately humanitarian assistance and relief to Gaza and take all measures to prevent destruction of evidence.
So you said this happened January 26th.
That's right.
And now, several months later, have we seen changes in how Israel is conducting warfare in Gaza?
One of the orders was that Israel must submit a report within 1 month. So that was February 26th. So Israel has submitted that report. That report is not made public, but there are already many, many allegations. And in fact, South Africa has applied to the court for even more urgent measures directed at Israel not complying with these initial orders on January 26th.
Recently, the UN Security Council passed a resolution for a ceasefire during the celebration of Ramadan, which is not going to last for much longer. Will that make a difference with how Israel is conducting warfare?
It's a travesty for international justice that the UN Security Council has not been able to act until now. And of course, that's due to primarily the veto power of the United States. Security Council decisions are legally binding on all member states. So Israel must comply and all member states must comply in terms of the immediate ceasefire. Now, it's noted by you, of course, that the ceasefire is only during the month of Ramadan. So the UN Security Council has to reconvene and not only look at whether the ceasefire has been complied with, but also what measures next after Ramadan.
So I also understand that you are a professor of international law here in Taiwan, and I would love to hear your take on Taiwan and international laws. So what is Taiwan's role in upholding international law?
Taiwan is a subject of international law, and Taiwan has responsibility, just like any other state, to uphold international law and to respect international law. So this will be done consistent with Taiwan's existing treaties, Taiwan's domestic law, and also an important thing, which is consistent with international custom. Now, international custom are rules that are so widespread, so basic for humanity, that all states must sign up to.
And what about Taiwan's responsibility in complying with ICJ orders?
So firstly, I believe Taiwan should ratify, domestically legislate some core international treaties, such as the Genocide Convention and the 2 additional protocols, and the Rome Statute of the International Criminal Court. Because right now, severe crimes such as genocide, war crimes, and crimes against humanity, they're actually not crimes under Taiwanese domestic law. With respect to the ICJ decision in the South Africa-Israel case, Taiwan's obligation would be to ensure that it complies with the orders of the ICJ. Taiwan is not directly a party to that case, but of course, should Taiwan be intentionally or unintentionally supporting Israel in terms of any military or financial support, this will be a very, very serious matter, because should the court in 3 or 4 years' time find that Israel is guilty of having violated the Genocide Convention, that would have implications on all states who conspire with Israel or are complicit in supporting Israel in a joint enterprise. Now, of course, those legal thresholds may be high, but it is responsibility of all states. But also Taiwan should be careful about the companies who may be supplying through the supply chain, exporting such materials that may be used to by the Israeli army to commit these crimes.
Thank you so much for joining us, Kevin. Very insightful.
Thank you, Herel, and hope to be back again. Cheers.
This has been Zoom In, Zoom Out. For more stories from TaiwanPlus News, follow us on social media. Thank you all for watching, and we'll see you next time.